CA final students, I have observed over the last few attempts that there will be one question on customs case law for around 4 marks. So, in order to quickly summarize what are all the various customs case laws that we have, I just wanted to post this video. So, you just listen to this video, and I am referring to all the customs case laws that we have in our ICI study material. So, these case laws, if you quickly recap this one day before the exam, definitely it will be helping you out. So you don't have to do anything, just listen, so nothing else, and so that this case laws as many number of times as you revise, so that in the exam you will get a situation and you need to write this case decision and you need to give the reference also if you are able to remember. So now, should we remember the case names? Make an effort to remember the case names. Worst come, if you are not able to remember the case name also, it's okay. As per decided case, so whatever is the decision, so but decision and the issue that you should be knowing. So what is the issue and what is the decision? So that decision at least you will be able to write. So now, without further delay, quickly we are moving on to the first area, that is taxable event in case of import of goods. So there is one case, Garden Silk Mills case. So that is by Supreme Court. So this is there in your page 1.10 of study material. So what is this case about? Let's see the issue. So what is the taxable event in case of import? Is it the date when goods enter into the territorial waters, or is it the date when goods cross the customs barrier? For which Garden Silk Mills case, the Supreme Court observed that import of goods will commence when they cross the territorial waters. Why? Crossing of territorial waters will be taken as the import, because import means import into India. Meaning of India is up to 12 nautical miles from the baseline. So therefore, whenever it crosses the territorial waters, the goods are said to be imported, but continues and is completed when they become part of the mass of the goods within the country. So what they're telling, whenever the goods crosses the customs barrier and merges into the landmass of the country, then only it will be called as import. This as per Garden Silk Mills case. One more case is also there, Kiran Spinning Mills case. So this Kiran Spinning Mills case is mainly for warehousing. So in case of warehoused goods, customs barrier would be crossed when they sought to be taken out of the customs and brought to the mass of the goods in the country. From these two cases, what is the summary that you can remember? As per Garden Silk Mills case and Kiran Spinning Mills case, the Supreme Court held that whenever goods crosses the territorial waters, import commences, and the import is completed only when goods cross the customs barrier. That is the time at which we file the into-born bill of entry or bill of entry for home consumption. So that is about these two cases. This Garden Silk Mills case is also important for one more purpose. So that we have in a different place, that is in page 4.46 related to valuation also. So therefore, have a look into this question. Mother Mary Hospital and Research Center imported a machine from Delta Scientific Equipments, Chicago for in-house research. The price of the machine was settled at $5,000. The machine was shipped on 10th April. Meanwhile, the hospital authorities negotiated for a reduction in the price. As a result, Delta Scientific Equipments agreed to reduce the price by $850 and sent a revised price of $4,150 under a telex. The machine arrived in India on 18th April. Now, what should be taken as a transaction value? Generally, the transaction value should be the CIF price, that is the price prevailing at the time and place of importation. But here what happened, the Commission of Customs has decided to take the original price as the transaction value of the goods on the ground that the price is reduced only after the goods have already been shipped. So do you agree with the stand taken by the department? Again here, Garden Silk Mills case, the same Garden Silk Mills Supreme Court case has given a view that no, the commissioner's approach is not correct. The price prevailing at the time and place of importation. At the time and place of importation, whatever is the price that should be taken. So, Supreme Court has held that importation gets complete only when goods become part of the mass of goods within the country. Therefore, since in the instant case, the price of the goods was reduced while they were in transit. So, therefore, we cannot take the original price. We need to take the price actually paid at the time of importation. So because the taxable event is at the time of importation, that is crossing the customs barrier, at that time what is the price? So 4,150. So that should be taken. Then the next case is related to relevant date for rate of duty in case of import. For that we have one Supreme Court case, Bharat Surfangs Private Limited case. So usually we need to take the relevant date for determination of rate of duty on the date of presentation of bill of entry or arrival, whichever is later. So here what has happened is that, so there is a entry of the ship. So ship entered the Bombay and made prior entry on 4/7/81. At that time, the rate of duty was 12.5%. So as there was no space, the ship proceeded to Karachi. So it went to the outside country and again it came back on 23/7/1981. By that time, the rate has been revised to 15%. Now, what should be taken? So the arrival here, is it the first arrival or the final arrival? What should be taken? Supreme Court held that rate of duty applicable will be 15% since the formality of entry inward could be done only on 4/8. So therefore here the date, if the ship has first come and again left, or aircraft has first come and again left and it is coming thereafter, the time when it is finally coming into India, that should be taken as the relevant date for the purpose of determination of rate of duty. And of course, we need to compare it with bill of entry, whichever is later should be taken. That is about Bharat Surfangs Private Limited case. The date of final arrival or grant of entry inwards, final grant of entry inwards is only relevant. There is one more case, that is Rajkumar Knitting Mills case. That is also Supreme Court case, wherein it is said, telling that, so again, the case is referring to contract price. What should be taken as the relevant rate of duty? So relevant rate of duty at the time of contract is not relevant. So we need to take as per section 15, that is date of presentation of bill of entry or grant of entry inwards, whichever is later, or date of presentation of bill of entry or arrival, whichever is later. So at the time of entering into contract, whatever is the rate of customs duty is there, that should not be taken. That is about Rajkumar Knitting Mills Private Limited. Then the next case that we have is Summer Timber Corporation. It's a Bombay High Court case which says that usually we need to take date of presentation of bill of entry or arrival or grant of entry inwards, whichever is later. Which bill of entry? Sometimes we present a bill of entry and thereafter, so that bill of entry we may rectify or amend and we need to present the corrected bill of entry. Now, which should be taken? Is it the first bill of entry or the corrected bill of entry should be taken? So for which they are telling relevant date in respect of rate of duty is at the date of presentation of bill of entry, the first bill of entry, not the date of representation after correction. So don't take it after correction. So you take at the time when we file the first bill of entry only, not after correction. So that is about Summer Timber Corporation. So these three cases are related to relevant date for rate of duty. Then next we have related to interpretation of exemption notification. In that, the first case is Kanishka Trading versus UI. In that, what has happened is that, so whether the power to exempt includes power to modify or withdraw in terms of section 21 of General Clauses Act. So here what happens, so when they give an exemption, so central government is having power to give the exemption. So can it be modified? Once the exemption is given, can the exemption be modified or revoked, and if it is in the public interest to do so? So they are telling that, so here, so as per section 21, it was held that a time-bound exemption notification issued under 25 can be modified and revoked in public interest. So once a notification is given, so it can be modified or revoked, and the doctrine of promissory estoppel cannot be invoked since a notification cannot be said to making a representation or a promise to a party or getting benefit thereof. So that cannot be done. So it does not mean that once a notification is given, which means that that will be binding, not like that. So the power to give exemption notification also includes in its power the power to modify or revoke that exemption. Then another case, Pankaj Jain agencies. So here what they're telling is that what is the relevant date for the purpose of the notification? Is it the date mentioned in the notification or is it the date published in the notification, like when it is published in the official gazette, which should be taken? So what they're telling is that notification is taken to effect from the date of its publication in the official gazette. For example, notification date is 4th November, but it got published in 8th November. So 8th November should be taken. That is about Pankaj Jain agencies, Supreme Court decision. Another case, ITC Limited, a Supreme Court decision only this is. So they are telling that, so non-availability of gazette on the date of issue of notification will not affect the operativeness and enforceability of the notification, particularly when there is radio announcements and press releases explaining the changes on the very day. So here, publication in the official gazette does not mean print. So it can be as a press release also. So that will be taken as the publication. So that is about this ITC Limited case. Then next one is related to Tullow India operations case. So that is what has happened in this. Let's try to understand the issue. So a person has imported some goods and that goods will be exempted provided they get a certificate from the Ministry of Hydrocarbons. Now this person has made the application with the Ministry of Hydrocarbons, but the Ministry of Hydrocarbons has not given that certificate on time, because of which the customs authorities have denied the exemption, for which in Tullow India Operations Limited Supreme Court case, it is held that so when there is a condition for an exemption and that condition is not within the control of the importer, so on account of non-compliance of that condition, the exemption cannot be denied. So that is what they're telling. So in this case, what has happened? When a condition is not within the power and control of importer and depends upon the act of the public functionaries, non-compliance of such conditions subject to just exceptions cannot be held to be condition precedent to which it will be disabling it from obtaining the benefit. So in this case, so they are telling that this person should enjoy the benefit. Then another case is Hanil Era Textile Limited case. So wherein they are telling that, whenever there is a restriction given in the notification, we need to make a literal interpretation of that restriction. And for example, so in this particular case there is an issue. A person has imported diesel generator set. Using the diesel generator set and furnace oil, they need to generate the electricity. That electricity generated should be used in production of exported goods. And here they use the generator for making the electricity in turn used for production of exported goods, but there will be some surplus electricity. That surplus electricity, they sold it to outsiders. So now the government is telling, customs department is telling that they will not get the exemption notification. So nowhere in the notification it is clearly mentioned that it should be exclusively used in manufacture of finished goods for export. So it should be used is what they have specified, but they have not mentioned the word exclusively used. So therefore, Supreme Court agreed to the view taken by the tribunal that in the absence of a restrictive clause in the notification, that is, imported goods are to be solely or exclusively used for manufacture of goods for export, there is no violation of any condition. So therefore, they cannot demand any duty. Okay, so because they have imported the DG sets and furnace oil duty free, and they have generated the power and it is used in manufacture of exported goods, only the surplus power has been sold, as the power cannot be stored. So Hanil Era Textiles Limited case, wherein so whenever there is no restriction in the notification, exemption notification, we should not add that restriction. So then another one is related to exemption from payment of duty. Usually there are various sections that we have. That is section 22, which talks about abatement, 23, which talks about remission of duty, so pilferage, etc. All these sections are talking about non-payment of customs duty. But here, when the goods are in transit and there it got destroyed, in that case, first of all, is there a levy? So in case of import of crude oil, whether customs duty is payable on the basis of the quantity of oil shown in the bill of lading. Bill of lading means like in the document of title, or the actual quantity received into the shore tanks in India, for which Supreme Court in Mangalore Refinery and Petrochemicals Limited, they are telling that when the goods are lost in the transit, first of all, there is no levy. So therefore, finally, what court is telling, so that conclusion is what you need to remember. The Supreme Court set aside the tribunal judgment and declared that the quantity of crude oil actually received into the shore tank in a port in India should be the basis for customs duty. So only customs duty is payable on the unloaded quantity. So if any transit loss happened, there is no levy and a question of exemption, remission, etc. does not arise. So customs duty levy itself is only on the quantity that is being unloaded. So that is about this Mangalore Refineries case. So Mangalore Refinery and Petrochemicals, it's a Supreme Court case related to exemption. The next one related to classification of goods. So first one, Saurashtra Chemicals. So Saurashtra Chemicals case in 1986 will be the basis for the purpose of bringing Rule 1. So Rule 1 of General Interpretative Rule says that the titles of headings or for reference only, the classification will be based on section notes and chapter notes. So we need to refer to section notes and chapter notes, and then only the classification needs to be done. So this is Saurashtra Chemical Supreme Court case, wherein they are telling that section notes and chapter notes in the tariff are part of the statute and relevant in the matter of classification of goods. And then they're telling these notes in this sense have overriding effect on the headings. So headings is not relevant. So section notes and chapter notes are relevant for the purpose of classification. Then another case, Mastro Motors Limited. In this Mastro Motor Limited case, what has happened is that, so one exemption notification was given. In that exemption notification, they are telling electronic automatic regulators falling under so and so heading is exempted, like that they are telling. Now, what about the period before that exemption notification? So before that exemption notification date also, those electronic automatic regulators will come under that heading number only. So department cannot change the heading. So if a tariff heading is specially mentioned in the exemption notification, the general interpretive rules will be applicable to such exemption notification. And for example, if they are not mentioning that particular heading, so if they are telling motor vehicles is exempted, motor vehicles is exempted means motor vehicle falling under any heading will be exempted. Suppose if they say motor vehicle falling under 8702 is exempted, then motor vehicle falling under 8702 only is exempted. Other motor vehicles will not be exempted. But if an item is specially mentioned, that is motor vehicles, without any tariff heading, then the exemption would be available, even though for the purpose of classification it may be otherwise. So Mastro Motor Limited, you remember this motor vehicles example. So motor vehicles imported falling under so and so heading is exempted. Means if the motor vehicle imported falls under that heading only, then it is exempted. If the motor vehicle imported is exempted, means if that motor vehicle is coming under any heading, it will be coming under exemption only. So then we have Hewlett Packard India Sales Private Limited case. Actually, this case is related to import of operating software along with the laptops. So whether the operating software should be added to the cost of the laptop, or software we have a separate exemption should be claimed. So for that, what they're telling is that laptop will not work without the software, even though separately when you are importing software we have an exemption, because software will be coming under services, we have separately exemption. But laptop along with software has to be classified as laptop and the valuation to be made as one unit, because a laptop will not work without the software. What if laptop is separately imported and software is separately imported? On laptop only customs duty applicable, on import of software there is no customs duty, and that is exempted because it will come under services. Then the next one is Canehan Penalpha Limited case. So here this is about that electronic automatic regulators I was talking about. Electronic automatic regulators were classifiable under 8543. So because an exemption notification was given which says that electronic automatic regulators, so coming under 9032 is exempted, means even before that period also. So court is telling that even before that period, before the date of exemption notification, it should be classified under 9032. Why there is a dispute? Because department itself agrees that in a exemption notification, the product is coming under so and so heading, means that heading only it will be classifiable even before the date of that exemption notification. Then related to valuation of goods, we have one case. So that is Bombay Dyeing and Manufacturing Company Supreme Court case, which says that only the payments actually made as a condition of sale of imported goods by the buyer and to the seller will be includable in the assessable value. So there is something called as vendor inspection charges. This vendor inspection charges on the goods carried out by the foreign seller on his own account. So foreign seller has carried out on his own account and not required for making the goods ready for shipment. So if any expenditure is incurred by the exporter as a condition of sale and it is recovered from the importer, then it should be included. In this case, it is not recovered from the importer, it is incurred by the exporter. So the charges of vendor inspection on the goods carried out by the foreign supplier on his own account are not required for making the goods ready for shipment, or not includable in the assessable value of the imported goods. So that is about Bombay Dyeing and Manufacturing Supreme Court case. The next case is Denso Kirloskar Industries Private Limited and also SR Steel Limited. That is, after importation, if we are required to pay any technical know-how charges to the exporter or any person on behalf of the exporter, whether those charges are to be included. Actually, post importation expenses should not be included in the assessable value for the purpose of payment of customs duty. So therefore, what they are telling is that, so whenever the cost is incurred after importation of the goods, it cannot be added to the assessable value, it cannot be loaded to the assessable value. And the same decision is also given in SR Steel Limited. Either you can write SR Steel Limited case or you can write Denso Kirloskar Industries Private Limited, but the decision is simple. The conclusion is that after importation, if any amount is payable as royalty charges or technical know-how charges to the exporter or any other person on behalf of the exporter, those costs will not be included in the assessable value of imported goods. Then the another case is Mangalore Refineries case. This Mangalore Refinery case already we have come across an exemption, so which says that whenever imported goods are unloaded and thereafter it is lost, so first there is a levy and thereafter the exemption we can claim. But before unloading itself, if the goods are lost, whether we need to claim any exemption, is there a levy? No, there is no levy in that case. So that case only here it is clearly given. So what is the conclusion here? Already we have seen the quantity of the goods imported will be the quantity of goods at the time they are entered for home consumption. Whatever is that only should be taken. Then the next one is related to Hyderabad Industries Limited Supreme Court decision. This is related to charges paid to the canalizing agent. So basically this canalizing agent is an agent who will be like an intermediary between the exporter and the importer. This canalizing agent will purchase the goods from the exporter and thereafter they will be selling it to the importer. So there are some goods which are reserved for state trading enterprises under foreign trade policy. So these goods can be imported only by state trading enterprises like MMTC, Multi-Metal Trading Corporation, Food Corporation of India, or ONGC. So they only can import the goods. So now these are people like canalizing agent, only they can import the goods from the exporter. Thereafter they will be selling the goods to the importer, in the sense they will be just passing on the goods to the importer, for which this canalizing agent will be collecting some charges. These are not called as buying commission. So because this canalizing agent are not the agent of the importer and they are not representing the importer outside India, so these charges are not called as buying commission. So therefore these charges, hence the commission or service charges paid to canalizing agent, are includable in the assessable value and this cannot be termed as buying commission. Okay. Then next one is related to Agarwal Industries Limited. So this Agarwal Industries case is related to like say, so there is one question for this. So let's see the facts of that case, then you will get an idea about it. So question number 5. An importer entered into contract for supply of crude sunflower seed oil at 435 CIF per metric ton. Under the contract, the consignment was to be shipped in the month of July. The period was extended by mutual agreement and the goods were shipped on 5th August at old prices. In the meanwhile, the international prices have gone up due to volatility. So they have not delivered the goods on time, the prices have gone up. But what has happened is that the importer did not charge the increased price. Okay, but department sought to increase the assessable value on the basis of the higher prices of contemporaneous imports, decide whether the contention of the department is valid, for which in Agarwal Industries, Supreme Court is telling that if the goods price is volatile and if there is any increase in the market price, what is the price prevailing at the time and place of importation payable by the importer to the exporter? Any price actually paid or payable by importer to exporter should be taken. In this case, a contract price only, because the importer did not charge any additional price to the or revised price to the importer. Exporter did not charge any revised price. Due to that reason, the price prevailing at the time and place of importation payable by importer to exporter should be taken. So that is this Agarwal Industries Supreme Court decision. And next one, Gira Enterprises. In this case, what has happened is that, so Customs Department, based on contemporaneous imports, that is comparable imports, have rejected the transaction value, but they did not give any reference as to why the transaction value is rejected and what are those comparable imports. So because of which the Supreme Court is telling that whenever Customs Department rejects the transaction value declared by the importer, so based on some alleged comparable imports, the details of those comparable imports should be made available to the importer and they need to get an explanation from the importer. Only then the rejection of transaction, whatever value declared by the importer is justifiable. So therefore, the Supreme Court held that mere existence of alleged computer printout was not proof of existence of comparable imports. Even if assumed that such printout did exist and the content thereof was true, such printout must have been supplied to the appellant, that is to the importer, and they should have been given reasonable opportunity to establish that the import transactions were not comparable. Then another case is related to liability to pay duty on custodian. So have a look into this question. Messrs. Pipley Imports Limited imported certain goods which were unloaded in the customs area on 1st October. When the order for clearance was passed by the proper officer on 5th October, it was found that there was some pilferage of such goods. So generally section 13 talks about pilferage, that is petty theft, and this is after unloading before order for clearance. As the imported goods were in the custody of the port trust, the department demanded duty from the custodian under section 45 subsection 3 on such pilferage. The port trust denied such demand, contending that it was not an approved custodian falling under section 45. Yes, so the port trust should be notified as the custodian. Custodian is a person who is appointed or notified by the commissioner. So here they should have been notified or approved custodian, and the possession of goods by it was by virtue of powers conferred under Major Port Trust Act. Hence it is not liable for customs duty on pilfered goods. Actually their contention is correct. Messrs. Pipley Imports has asked the port trust to make good the loss of the goods. So definitely they cannot ask. Even the importer cannot ask the port trust authorities. So examine whether the demands made by department and Pipley Imports are justified in law. So first aspect, can the department recover the customs duty from this particular person, port trust authority, when they are not authorized as custodian? So for which we have Board of Trustees versus UI, Bombay High Court case. So what they are telling is that, so department cannot demand duty from port trust on pilferage under section 45 because they have not been authorized as a custodian. And so section 45 says that custodian responsible only in respect of customs duty in pilfered goods, but it does not extend to the value of the goods. Now, whether this Pipley Imports Limited importer can demand the loss of the goods from the port trust. However, the port trust as bailee of the goods is liable for value of goods to the importer. They are not required to pay customs duty to the customs department, but as they keep the goods as a bailee, so when the goods are lost, so they have to repay the value of the goods. Basically, this will be covered under the insurance. So that is about this case. Then next we are moving on to warehousing. In warehousing, we have Pratibha processors case. So in this Pratibha process case, the case is simple. I am importing the goods and keeping the goods in the warehouse, and at the time of clearance from the warehouse, the goods became exempted. As the goods became exempted, I am not required to pay the customs duty. But these goods are kept in the warehouse beyond 90 days from the warehousing order, because of which whether I need to pay any interest. So when the customs duty liability itself is nil, the warehousing interest will also be nil. So court held that when goods at the time of removal from the warehouse are wholly exempt from payment of duty, the liability to pay interest cannot be saddled on a non-existing duty. So as the duty is nil, interest also will be nil. Same is the case when the goods are exported. So when the goods are kept in the warehouse and thereafter exported, there is no duty liability. Even though the goods are kept in the warehouse beyond the permissible 90 days interest-free period, so interest payment shall not arise, because at the time of export of goods from the warehouse, we don't have to pay customs duty. So interest also does not arise. A very important case, Pratibha processors case. Then the next case is related to Kesoram Rayan case. In Kesoram Rayan case, Supreme Court held that if the goods are not cleared within the permissible warehousing period, on expiry of the permissible warehousing period, the goods are deemed to be improperly cleared, and on that date, whatever is the rate of duty that should be taken, even though the ex-bond bill of entry is filed at a later point of time. But at the time of expiry of warehousing period, we need to treat that the goods are improperly cleared. Customs duty can recover, customs department can recover the duty from the importer, and the rate of duty prevailing at the time of expiry of warehousing period should be taken. Then next one, so this is BECO Lorry Limited case. So have a look into the question related to this particular case. BL Limited imported superior kerosene oil and stored it in a warehouse, and an ex-bond bill of entry was filed and duty is paid. So they filed an ex-bond bill of entry and they paid the duty. But on account of highly combustible nature of SKO, the importer made application to permit the storage of that kerosene oil in the same warehouse until actual clearance for sale or usage. So until the actual clearance for sale or usage, so the importer is asking for permitting them to keep the goods in the warehouse, and the application was allowed. However, the rate of duty increased when the goods were actually removed, and the department demanded the differential duty. So in this case, the Bioco Lorry case, Bioco Lorry Limited case, Supreme Court is telling that once the ex-bond bill of entry is filed and the customs duty rate prevailing at the time of ex-bond bill of entry should be taken, even though by virtue of section 49, the goods are kept in the warehouse even after payment of duty, it does not mean that, so we need to pay any increase in the customs duty. So therefore, when in Supreme Court held that when duty on warehouse goods is paid and out of customs charge order for home consumption is made by the proper officer, so the goods allowed to be retained in storage, so are not treated as warehouse goods, an importer would not be required to pay anything more. Then the next case is in refunds, Mafatlal Industries Limited. So this is a Supreme Court case. In this, they are telling few points, so few principles are laid down in this judgment. Mafatlal Industries Limited. First, the theory of unjust enrichment is valid and constitutional. So every importer should prove that, so the burden is not transferred to the next person. If he fails to prove that the burden is not transferred to the next person, he will not be eligible for the refund. And next principle is that, so whatever amount is collected as duty by misrepresentation, some amount is collected as customs duty from the person, subsequent person, by the importer. So that amount collected as duty should also be paid to the government, even though that is not his actual liability. By representing it as customs duty, it has been recovered from the next person. So the importer has to pay that amount collected. The person who borne the incidents can claim the refund, otherwise it will be transferred to consumer welfare fund. So that is about this. Then next one, allied photographics case. So in this allied photographics case, it is telling that whenever the duty has been paid under protest, duty has been paid under protest means you are importing the goods and the department asks you to pay some duty, but according to you, you are not required to pay the duty, but you need the goods. So therefore you paid the duty and you got the goods. At a later point of time, now you are going for appeal, and wherein, so it is held that you are not required to pay. Now you are getting the refund. Now should you prove that unjust enrichment? Yes, you need to prove unjust enrichment. Of course, there is no time limit for making refund application. So, but you need to prove unjust enrichment. So that is this allied photographic Supreme Court case, wherein they are telling that the doctrine of unjust enrichment applicable even in case of duty paid under protest. Then next one. So Priya Blue Industries Limited case. This case is little different. What has happened? A person was asked to pay some duty and he paid the duty, but he came to know that is excess. He paid the duty and he should have gone for appeal. Instead of going for appeal, he made a refund application stating that I have made some excess payment of duty. That is not the correct method of redressal. So whenever you are not agreeing to that duty amount, you should have gone for appeal. Okay, that is the proper methodology in this case. So here, the duty was assessed on the import item and the importer paid the duty under protest. Thereafter, importer filed a claim for refund of duty. In this matter, the Supreme Court ruled that once an order for assessment is passed, then the duty would be payable as per that order. So unless the assessment order has been reviewed in an appeal, so you will not be able to fight for this. So refund claim is not appeal proceeding and refund is not an alternative to appeal. Then some important judgments, and the same issue whatever we have seen in Priya Blue Industries is also held in ITC Limited case, wherein it has been held that appeal is required to be filed and not refund claim even in respect of self-assessment. Then some more cases. So can the customs house agent file the refund application on behalf of importer without power of attorney? No. So only with the power of attorney, customs house agent can make the refund application, and burden to prove that the incidence of duty has not passed on to consumers is on the assessee who is making the application. And then one more, interest on delayed refund. So whenever there is some interest on delayed refund, so refund should be granted within 3 months from the date of application. If not, interest is payable at 6%. So this is 6% is at present, but at that time when the refund was due, say the refund was due for 1 year, in that 1 year for a few months we have 9% interest, for a few months we have 6% interest. Even though at the time when they are giving refund 6% is there, should the 6% be taken, or at that time whatever was the interest rate that should be taken? Interest on delayed refund is payable at the rate applicable from time to time and not at the rate applicable on the date on which refund was due. Then next case, last case, this is SRF Limited case. So this case is related to one issue. So have a look into the question here. XYZ Limited imported capital goods and used them in the factory to produce goods for sale. Upon discovery of an error by which excess import duty has been paid on the said capital goods, it filed a refund claim. Okay, so by error by which excess import duty has been paid on the capital goods, they made a refund application. As regards unjust enrichment, it contended that the capital goods were not sold. Hence, the principle of unjust enrichment will not apply to the refund of import duty. That in any case, the price of the finished goods manufactured in the factory remain the same. See, not necessary that the capital goods needs to be sold. But using that capital goods, we are making the finished goods, and whatever customs duty we paid on the capital goods would have been passed on to the finished goods, and we would have absorbed the extra customs duty paid on the finished goods. For that they are telling, but the price of the finished goods manufactured in the factory removed the same before or after import and installation of the capital goods was sufficient proof to establish that duty burden has not been passed on. So for which, so in this SRF limited case, the tribunal larger bench is telling that just because the price of the finished goods is same, uniform, does not mean that unjust enrichment does not happen. So the price became uniform because of many reasons. Maybe the raw material cost would have decreased, and the capital goods extra custom duty paid would have been recovered, because of it the price is same. So there are many reasons. So therefore, doctrine of unjust enrichment would be applicable in case of imported capital goods as used captively for manufacture of finished goods. As regard the relevance of the fact that price remained the same before and after the capital goods were imported, uniformity in price does not lead to inevitable conclusion that the burden has not been passed. Such uniformity may be due to various reasons, so because of which they have to prove unjust enrichment. So these are the various cases that we have in the study material. So these cases, if you study, that will be sufficient. Because of the updated study material, they have not given everything. So these cases really sufficient for your exam. So make a quick revision of this 2-3 times, and so that, so if at all this particular issue comes in the exam, you will be able to write the answer.